Oh, hello. Welcome to my bar review show. Today we're talking about civil procedure. Civil procedure involves three main sections: jurisdiction and venue, pleadings, and start to finish. I tack choice of law onto jurisdiction and venue, and I tack multiple parties and claims onto start to finish. So you see we have jurisdiction and venue with choice of law, we have pleadings, we have start to finish with multiple parties and claims. Let's start out. Jurisdiction and venue involves subject matter jurisdiction, personal jurisdiction, and venue. Subject matter jurisdiction. We'll talk about it in general. We'll talk federal question jurisdiction, diversity jurisdiction, supplemental jurisdiction, and removal jurisdiction. Subject matter jurisdiction. In general, courts' competence to hear and determine cases of general class and subject to which proceedings in question belong. Federal question jurisdiction. In general, district courts have original jurisdiction over all civil actions arising under U.S. Constitution, laws, or treaties. Concurrent or exclusive jurisdiction. State and federal courts have concurrent jurisdiction of federal question claims, except when Congress expressly provides federal jurisdiction is exclusive. Scope. Express. Federal question exists if cause of action in question is expressly created by federal law, and federal law provides underlying right. Implied. Federal question is likely to be found if right is created by federal law, as well as cause of action can be fairly implied and was intended by Congress. Not express or implied. Complaint must involve state claim that is necessarily raised, actually disputed, substantial, and capable of federal court resolution without disrupting federal-state balance approved by Congress. Well-pleaded complaint. Federal question exists only when federal issue is presented on complaint's face. This would be plaintiff's cause of action, not any defenses, answers, or counterclaims. There's no amount in controversy or diversity requirement. All right, diversity jurisdiction. In general, federal courts have jurisdiction when parties are citizens of different states or citizens of state and citizens of foreign state, and amount in controversy exceeds $75,000. Complete diversity. No diversity if any plaintiff is citizen of same state as any defendant in case. Party citizenship. Individuals. Domicile is state in which individual is present and intends to reside for an indefinite period. An individual can only have one domicile at a time. Domicile is determined when action is commenced. Party citizenship. Corporations. Citizenship is state of incorporation and state where corporation has its principal business place, its nerve center from which high-level officers direct, control, and coordinate corporation's activities. Controversy amount. Proof standard. Plaintiff's good faith assertion in complaint is sufficient unless legal certainty exists. Plaintiff cannot recover alleged amount. Claims aggregation is permitted for a single plaintiff against a single defendant, or multiple plaintiffs with common undivided interest. Counterclaims generally are not counted in determining whether plaintiff has met amount. Permissive counterclaim must meet jurisdictional amount requirement. Compulsory counterclaim need not. Creating or destroying diversity. 1. Claims assignment. 2. Failure to name indispensable parties. 3. changing state citizenship voluntarily, and 4. Parties replacement. Extra. Federal courts cannot exercise diversity jurisdiction over probate or domestic relations. State courts have exclusive jurisdiction over these cases. Supplemental jurisdiction. In general, a federal court with jurisdiction may exercise supplemental jurisdiction over additional claims over which court would not independently have subject matter jurisdiction, usually state law claims against a non-diverse defendant, but that arise out of a common nucleus of operative fact, such that all claims should be tried in a single judicial proceeding. Federal question. Additional claims against same party can be heard through supplemental jurisdiction if common nucleus of operative fact test is met. Same requirements for pendent jurisdiction over claims involving joinder or intervention of additional parties. Diversity jurisdiction. Permissive joinder. Addition of plaintiff asserting additional claim cannot violate complete diversity rule and is not required to satisfy the jurisdictional amount. Counterclaims. Compulsory counterclaims need not satisfy jurisdictional amount, but permissive counterclaims must satisfy both diversity jurisdiction requirements. Cross-claims may be asserted by defendant against another defendant or by plaintiff against another plaintiff if cross-claim arises out of same transaction or occurrence as initial claim. There's no amount in controversy or citizenship requirement if court has subject matter jurisdiction over original complaint. Extra. Court may exercise supplemental jurisdiction over claim that does not independently satisfy subject matter jurisdiction requirements when claim shares common nucleus of operative facts, arises out of same transaction or occurrence, as claim within court's original jurisdiction. Removal jurisdiction. In general, defendant may generally remove case from state court to federal district court with subject matter jurisdiction. Removal must be to district court for district and division in which state court action is pending. Removal to wrong district court is subject to remand motion, meaning transfer to proper federal court. Determination. Generally, remove right is determined by pleadings filed when removal petition is filed. Diversity jurisdiction. Diversity must exist at original action's filing time as well as time removal notice is filed, unless party preventing diversity is dismissed or non-diverse party against whom plaintiff has no colorable claim was fraudulently joined to defeat diversity. Diversity jurisdiction. If removal is based solely on diversity jurisdiction, claim may be removed only if no defendant is citizen of state where action was filed. This is the home court advantage rule. Federal question. If federal question claims are joined with claims that are not independently removable, entire case may be removed. Notice. Defendant must file notice within 30 days after receipt by or service on defendant of initial pleading. Federal question. Only defendants against whom federal claim is filed must consent or join in removal. Diversity jurisdiction-based removal cannot occur more than 1 year after action is commenced, unless plaintiff acted in bad faith. Remand. Subject matter jurisdiction lack. Any time before final judgment is rendered. Other reasons. Remand motion for any defect other than subject matter jurisdiction must be within 30 days after removal notice filing. All right, let's talk personal jurisdiction. It involves, in general, in personam, jurisdiction over things, notice and opportunity to be heard, defenses to jurisdictional claims, and extra. In general, there's three types: in personam, in rem, and quasi in rem. State long-arm statutes. Federal court will look to state long-arm statutes to determine if federal court has personal jurisdiction over parties. Due process. Federal court may not exercise personal jurisdiction over defendant unless defendant has minimum contacts with the forum state, and jurisdiction's exercise would be fair and reasonable. Consent. Party may expressly, impliedly, or voluntarily consent to personal jurisdiction. Defenses. Jurisdiction lack, process lack, or service of process insufficiency must be asserted in the responsive pleading, and failure to object waives the objection. In personam. Generally required whenever judgment is sought that would impose personal obligation on defendant. In personam jurisdictional basis, we got voluntary, domicile, consent, long-arm statute, and properties attachment. Voluntary. Appearance alone does not waive right to object to personal jurisdiction. Domicile. If authorized by statute, state has jurisdiction over person domiciled in state, person with capacity who intends to make that state his home. Consent. Defendant can expressly consent to jurisdiction via contract, or, once action is brought, impliedly via conduct, or voluntarily via court appearance, unless to object to jurisdiction. Long-arm statute. Authorizes personal jurisdiction over non-residents who engage in activity in state or cause some action to occur within state to extent permissible under due process clause. Property attachment. If claim is not related to attached property's ownership, minimum contacts must exist between defendant and forum state to establish jurisdiction. Due process requirements. Satisfied if non-resident defendant has certain minimum contacts with forum state, such that action's maintenance does not offend traditional notions of fair play and substantial justice. Minimum contacts. Purposeful availment. Defendant's contacts with forum state must be purposeful and substantial, such that defendants should reasonably anticipate or foresee being taken to court there. Specific and general jurisdiction. Specific jurisdiction. When cause of action arises out of or closely relates to defendant's contact with forum state, even if defendant's only contact. Specific personal jurisdiction is for that action only. General jurisdiction requires defendant to be domiciled in or have continuous and systematic contacts with the forum state. Confers personal jurisdiction even when cause of action has no relationships with defendant's contacts with the state. Imputed contacts, partnerships. Each partner is generally partnership's agent. Corporations. Out-of-state corporations' contacts with the forum state do not automatically establish jurisdiction over wholly owned subsidiary unless subsidiary is parent's alter ego or acting as an agent. Employees or agents. Contacts by non-resident employers, agents, or employees. Imputed to employer if acting within the agency or employment scope, not usually applicable to independent contractors. Fair play and substantial justice. Once minimum contacts are established, court must still examine facts to determine if action's maintenance would offend traditional notions of fair play and substantial justice. The factors include forum state's interest in adjudicating matter, defendant's burden of appearing in case, judicial system's interest in efficient resolution of controversies, and states' shared interest in promoting common social policies. In personam jurisdiction over corporations. Resident, incorporated in the forum state. Any action may be brought against resident corporation. Foreign, not incorporated in the forum state. Minimum contacts and substantial fairness rules apply. Test is whether corporation's affiliation with forum state is so continuous and systematic as to render corporation essentially at home in the forum state. Corporate defendant is always at home in his incorporation state and state of its principal business place, and in exceptional cases, state in which defendant's operations are so substantial and of such nature as to render court at home there as well. Internet website. Jurisdiction over non-residents' website is based on interactivity degree between the website and the forum state, ranging from passive sites to sites integral to defendant's business. Contract-based suits. Contract can be a significant factor in determining whether minimum contacts exist, and choice of law provisions are a significant factor as they establish non-resident purposely availed herself of forum state's law's benefits. Jurisdiction over things. In rem, definition. Court definition gives court authority to determine issues concerning real or personal property rights. Due process. Proceedings against property must still satisfy due process requirements for personal jurisdiction, and property must generally be present within forum state. Quasi in rem. Definition. Determines only interest of parties to action regarding property located in the forum state, like a lien, foreclosure, or quiet title action, and not personally binding against defendant. Due process. If disputes are unrelated to property ownership and no close relationship is formed in addition to having property located in the forum state, then minimum contacts must be shown between defendant and forum state. Notice and opportunity to be heard. Notice, the rule, must be reasonably calculated under all circumstances to apprise interested parties of pending action and afford interested parties opportunity to be heard. Form, via in-person delivery, registered mail, etc. If identification or address is known or obtainable through reasonable efforts. Opportunity to be heard. For defendant whenever there is state-sponsored interference with defendant's property interest. Defenses to jurisdictional claims. Special appearance to challenge personal jurisdiction and collateral attacks. This is abolished under the FRCP. Extra. 100-mile bulge rule establishes personal jurisdiction over party 1 added to suit via impleader or required joinder, and 2 served with process within 100 miles of federal court where suit is pending. Right, venue. We've got venue in federal court, venue change in federal court, and forum non-convenes. Venue in federal court. The general rule. Venue is proper in judicial district where any defendant resides, states where all defendants reside, or where substantial part of events or omissions occurred, or where property. I'm going to start this one over. Venue in federal court. The general rule. Venue is proper in judicial district where any defendant resides, state where all defendants reside, where a substantial part of events or omissions occurred, or where property that is subject of action is located. Otherwise, where any defendant is personal jurisdiction subject. Differently worded definition: venue is proper in any federal district where any defendant resides as long as all defendants reside in the same state. Substantial part of events occurred or substantial part of property at issue is located, or any defendant is subject to court's personal jurisdiction, if first two provisions do not apply. Residence: judicial district where defendant is domiciled for individual, where defendant is subject to personal jurisdiction for entity, or when entity is plaintiff, where principal business place is located. Extra: venue is geographic location of federal district court where case may be heard. When defendant is non-resident of U.S., venue is proper in any federal judicial district. All right, venue change in federal court. Original venue proper. So the original venue was proper. The general rule: transfer is permitted to any district where case might have been brought or to which all parties consent. Diversity jurisdiction: new district court must apply the law from the previous court. Federal question: new district court in another appellate circuit will apply federal law as interpreted by its appeals court, not appellate circuit of transferring district court. Original venue was improper. The general rule: dismiss or transfer the case to the proper district if it's in justice's interest. Diversity jurisdiction: district court to which case is transferred applies choice of law rules of state in which it is located, not court transferring cases state law. Federal question: new court will apply its own appeals court's interpretation of law, not appellate circuit of transferring district court. No personal jurisdiction: court lacking personal jurisdiction over defendant may transfer case to a different venue. Forum non-convenes. Federal: only used when forum deemed most appropriate for action is state or foreign court, generally defendant's burden, but if forum selection clause designates state or foreign court, if forum selection clause designates a state or foreign court, then the burden shifts to plaintiff. Let's start that over. Forum non-convenes. Federal: only used when forum deemed most appropriate for action is state or foreign court. Generally, it's defendant's burden, but if forum selection clause designates state or foreign court, then burden shifts to plaintiff. All right, choice of law, Erie. We've got in general, substance or procedure, federal common law, and state conflict of law rules. In general, federal question, federal substantive and procedural law, and federal common law controls. So if it's federal question, it means federal everything. Diversity jurisdiction, state substantive law and applicable federal procedural law. Supplemental jurisdiction, state substantive law for state law claim. Substance or procedure. Determination is unclear. We've got valid federal statute on point, no federal rule on point, substantive law, and procedural law. Valid federal statute on point. When state and federal laws conflict, you'll apply the federal law. Before applying federal rule rather than federal statute, court must determine rule is valid under Rules Enabling Act. Does federal rule abridge, enlarge, or modify any substantive right? If no, then apply the federal rule. If yes, then apply the federal rule if federal rule only incidentally affects litigants' substantive rights. No federal rule on point. Apply state law. If failure to do so would lead to different outcomes in state and federal court. Substantive law. Claim or defenses, elements, statute of limitations and tolling provisions, and proof burden. Procedural law. Judge or jury allocation, attorney's fees assessment, equitable or legal determination. Federal common law. We've got in general, federal question, diversity jurisdiction, and state court cases. In general, created when no applicable federal standard, statute, or constitutional provision exists. No general federal common law exists. General areas that federal common law is applicable to will be limited. Federal question. Apply federal common law in the following instances. Admiralty cases, when U.S. is a party to the case. Interstate disputes, cases implicating relations with foreign countries. Cases where government acts in proprietary role. And when Congress has left gap in statutory schemes. Diversity jurisdiction, when uniquely federal interest is at stake and significant conflict exists between that interest and operation of state law. State court cases, if state jurisdiction is concurrent with federal question jurisdiction and federal common law would have applied in federal court, then federal common law will also apply in state court. State conflict of law rules. Federal courts must apply states' conflict of law rules. District court diversity jurisdiction. District court is bound by state in which district court is located conflict of law rules, but only to extent states' rules are valid under full faith and credit and due process clause. Procedural or substantive law. Federal courts must apply states' conflict of law rules. States apply their own procedural laws and sometimes apply foreign jurisdictions' substantive law. Extra. Under Erie, state law applies if state law is outcome determinative and no countervailing federal policy interest exists. Let's take a long break. You can pause the video here and come back when you like. All right, we're back. Let's talk pleadings. Pleadings involve service of process, injunctions, complaint, motions against complaint, answer, reply, amendments, and supplemental pleadings, and Rule 11 sanctions. Service of process, timing, within 90 days after filing complaint. Extra, plaintiff must provide court with service proof when service properly made and not waived, but failure to provide court with service proof does not affect service's validity. Service methods for individual. Personally, at defendant's usual place of abode with person of suitable age or discretion who resides there, or delivering to defendant's agent. Service on corporations or associations, to officer or agent, or by following state law. Service waivers, waiver request, must be written and addressed to individual defendant or corporation's officer or agent, and must give defendant reasonable time, at least 30 days, after request is sent to return the waiver. Effect. extends time to serve answer from 21 to 60 days. All right, injunctions. Temporary restraining order. This preserves the status quo until a full hearing opportunity. It's only effective for a limited time, no longer than 14 days unless good cause exists or an adversary consents. It may be issued without notice to adverse party if immediate and irreparable injury will result from and movant's attorney certifies that efforts were made to give notice and reason why notice should not be required. It's not generally immediately appealable. Motion to dissolve. If issued without notice, adverse party may appear and move to dissolve or modify the temporary restraining order. Must give at least 2 days notice unless court sets a shorter time. Every order granting temporary restraining order must detail why the temporary restraining order was issued and acts to be restrained. Preliminary injunction. Issued prior to full hearing on the merits, on notice to defendant, may be issued to plaintiff if plaintiff is likely to succeed on the merits, plaintiff is likely to suffer irreparable harm in relief's absence, balance of equities is in plaintiff's favor, and injunction is in public interest. Permanent injunction. Once issued, it continues until dissolved by court, but any affected person may move for modification or dissolution. Same standard as for a preliminary injunction, but plaintiff must show actual success on the merits. Complaint. Federal rule. We need a short, plain statement of court subject matter jurisdiction, plaintiff's entitlement to relief, and demand for judgment, notice pleading. Timing. Filing generally occurs before service. Service generally is within 90 days of filing. Motions against complaint. Within 21 days of service. We've got a Rule 12b motion to dismiss, a Rule 12b-6 motion to dismiss, motion for judgment on the pleadings, Rule 12c, motion for a more definite statement, motion to strike, and amending motion. Rule 12b, motion to dismiss, subject matter jurisdiction lack, can be raised at any time. Personal jurisdiction lack, improper venue, or insufficient process or service. This can be raised in a pre-answer motion, or answer, or within time to amend answer as a right. Otherwise, it's waived. Omnibus motion rule. Motion raising one of these defenses but omitting others waives excluded defenses. Failure to state claim on which relief can be granted. Failure to state claim on which relief can be granted and failure to join necessary or indispensable party can be raised in any pleading, motion for judgment on the pleadings, or at trial. Rule 12b-6, motion to dismiss. In general, claim will be dismissed if claim fails to assert a legal theory of recovery cognizable at law, or allege facts sufficient to support cognizable claim, and court treats well-pleaded facts as true, resolves doubts or inferences in plaintiff's favor, and views pleading in light most favorable to plaintiff. Strength of facts. Must raise right to relief above speculation, assuming complaint's allegations are true, and raise reasonable expectation discovery will reveal evidence of necessary element. Court can consider only the allegation and attached exhibits in the complaint. Court's two-step analysis. 1. Identify and reject legal conclusions unsupported by factual allegations. 2. Assume well-pleaded facts' truth and veracity, and include context-specific analysis that draws on courts' judicial experience and common sense to determine if allegations plausibly give rise to relief. Motion for judgment on the pleadings, Rule 12c. After answer is filed, it allows the court to dispose case when material facts are not disputed and judgment on the merits can be achieved based on the pleading's content. Motion for a more definite statement. Responding party may move for more definite statement. If relief claim is so vague or ambiguous, party cannot reasonably draft responsive pleading. Motion to strike. Federal rule. Federal rule is when pleading contains insufficient defense or redundant, immaterial, impertinent, or scandalous material, court may order such defense or material stricken. Can be used to avoid unnecessary time or money in litigating invalid issues. Amending motion. Not specifically provided for in rules, but generally allowed by courts if party acts promptly. Answer. Admissions or denials. Answer must admit or deny plaintiff's allegations, or plead sufficient knowledge lack with reasonable investigation. Extra. Defendant's answer must include admission or denials of each allegation in plaintiff's complaint. Failure to deny these allegations generally results in them being admitted and conclusively established. However, damages related to allegations cannot be admitted by defendant's failure to deny them in answer. Affirmative defenses. Defendant must state affirmative defenses, or affirmative defenses are deemed waived. Timing. Service under Rule 5. Service to party with attorney must be made to attorney in accordance with Rule 5. No motion to dismiss. 21 days after being served with summons and complaint, or 60 days if defendant timely waived service. Extra. Answer must include omissions or denials, affirmative defenses, non-waived motions, and compulsory counterclaims. Motion to dismiss. No filing while motion is pending, and within 14 days after notice of court's action. Reply. Response. By plaintiff to defendant's answer within 21 days after being served with order to reply. Unless court orders otherwise, responding party generally must respond to amended pleading within the time that remains to respond to the original pleading, or 14 days after service of amended pleading, whichever occurs later. Amendments. The rule. A party may amend a pleading once as of right within 21 days if no responsive pleading is required, or after being served with answer or 12b motion. Otherwise, during or after trial, if it conforms to evidence an opposing party has prep opportunity. Court should freely give leave to amend pleading when justice requires and will not result in undue prejudice to opposing party. Relation back, a new claim. Relates back to original pleading's date if amendment asserts claim or defense that arose out of same conduct, transaction, or occurrence as original pleading. New party. Relates back to original pleading's date if amendment asserts claim or defense that arose out of same conduct, transaction, or occurrence as original pleading. New party receives notice of action within 90 days after original complaint is filed. Defendant knew or should have known about action, but for mistake concerning proper party's ID. Time to respond: within 14 days after amended pleading service, or time left on original pleading, whichever is later. Supplemental pleadings: to describe events occurring after filing of earlier pleading. Rule 11 Sanctions. Court may impose sanctions limited to what suffices to deter repetition of conduct by others similarly situated. Does not apply to mandatory disclosures and discovery request responses and objections. Types: non-monetary directives, penalties to court, or, if imposed on motion, payments to movement for attorney fee or other expenses directly related from violation. Let's take a long break. You can pause the video here and come back when you like. All right, we're back. We're on the last part, start to finish, which involves multiple parties and claims. Start to finish involves pre-trial, trial, and post-trial. Pre-trial involves mandatory disclosures, discovery scope and limits, discovery conference, discovery devices, enforcement, case management, and adjudication without trial. Mandatory disclosures, initial disclosures, generally subject to certain exceptions, must disclose info regarding individuals having discoverable info, docs supporting claims or defenses, damages computation and backup, or relevant insurance agreement for satisfying judgment. Standard: info reasonably available to it and party. Not excused for not fully investigating case, challenges to insufficiency of another party's disclosures, or because another party failed to disclose. Timing: within 14 days after party's discovery conference. Expert testimony: generally, identify expert witnesses and produce expert reports subject to certain regulations. Timing: at least 90 days before trial or 30 days after disclosure of opposing parties' expert evidence of same subject matter. Evidence to be presented at trial other than for impeachment. Generally, witness list by testimony or deposition, and docs and exhibits. Timing: at least 30 days before trial. Objections: within 14 days after disclosures are made or waived, unless court excuses for good cause or pursuant to Federal Rules of Evidence's relevance rules. Discovery scope and limits. Scope: generally permitted with regard to any non-privileged matter relevant to any party's claim or defense in action, proportional to case's needs. Relevance: info need not be admissible in evidence to be discoverable. Privileged info, not discoverable, determined under federal common law for federal question cases, state law for diversity jurisdiction or supplementary jurisdiction cases. Limitations: balanced discovery and privacy interest. Generally can't seek discovery until after discovery conference. Discovery sought is unreasonably cumulative or can be obtained from more convenient or less expensive source. Party seeking discovery had ample opportunity to get info by discovery. Proposed discovery is not relevant and proportional. Trial preparation materials. Party may not discover documents and tangible things prepared in litigation's anticipation or for trial unless other party shows it has substantial need for materials to prepare its case and cannot, without an undue hardship, obtain their substantial equivalent by other means. Mental impressions, conclusions, opinions, or party's attorney or other rep's legal theories are protected. Experts. Expert witnesses may be deposed, but expert report drafts and disclosure are protected, as well as any communication between party's attorney and expert witness, unless they related to compensation, facts or data used, or assumption expert relied on in forming his opinion. Discovery conference. Parties must confer at least 21 days before scheduling conference to consider nature and basis of their claims or defense, settlement possibility, automatic disclosures, preserving discoverable info, and developing discovery plan. This sets discovery scope and schedule. Discovery devices. Oral depositions can take place any time after discovery conference. It's limited to 10 per party, unless showing a good cause to court. Interrogatories. 25 written interrogatories per party relating to non-privileged matters, relevant to any party's claim or defense, and proportional to case's needs, must be fully and separately answered under oath unless timely objected to with specificity. Request to produce documents. Party has 30 days from being served with request, or 30 days from party's first Rule 26F conference to respond. Physical or mental exams. Court may order person to submit to physical or mental exam if physical or mental condition is in controversy. Request for admission. Party can serve written admission request of any relevant non-privileged matters relating to fact statements or opinions or law's application to fact, which once admitted is conclusively established. Enforcement. Motion to compel. Party can move to compel discovery's disclosure against party failing to make automatic disclosures, or to respond to discovery requests, including evasive or incomplete disclosure. Sanctions. If party fails to obey court order regarding discovery, court may impose sanctions subject to abuse of discretion standard. Electronically stored information. If info that should have been preserved is lost because party failed to take reasonable steps to keep it, then court may order measures to cure prejudice, or, if party acts with intent to deprive another party of info, then instruct jury. Jury may or must presume info was unfavorable to party, or dismiss action or enter default judgment. Case management. Pre-trial conferences. Court may direct counsel and unrepresented parties to appear for pre-trial conferences for purposes such as expediting actions disposition, effective case management, and facilitating settlement. Scheduling conference and order. Limits time to join other parties, amend pleadings, complete discovery, and file motions. Sanctions. Party who fails to appear or participate in pretrial or scheduling conference or fails to obey resulting order may be subject to sanctions or ordered to pay reasonable expenses. Adjudication without a trial. Dismissal of complaint, counterclaim, cross-claim, or third-party claim. Voluntary, by filing notice or by stipulation. A plaintiff can dismiss the action without court's leave any time before opposing party serves answer or motion for summary judgment, or by all parties who have appeared stipulation. Dismissal will usually be without prejudice, with 2 dismissal rule applies. By court order. Decision to dismiss with or without prejudice is left to court's discretion, often without prejudice, but not as a matter of right. Court considers whether dismissal without prejudice unfairly affects defendant. Two-dismissal rule generally is not implicated. Involuntary. When plaintiff fails to prosecute or comply with rules of court order, defendant can move to dismiss, which, if granted, is with prejudice and operates as adjudication on the merits. Default. When party fails to defend action, plaintiff may seek a default judgment, which can be set aside for good cause. Default judgment. Once default is entered, plaintiff may seek default judgment. Summary judgment. Standard. No genuine dispute as to any material fact, and movement is entitled to judgment as a law matter. Court will construe all evidence in light most favorable to non-moving party and resolve all doubts in non-moving party's favor. Proof burden. Movement has burden of persuasion to show prima facie case before burden shifts to opposing party to set forth specific evidence showing genuine fact issues' existence. Timing. May be filed any time until 30 days after all discovery's closure. Non-movement generally must be given sufficient opportunity to obtain discovery. Declaratory judgment. Court tells parties their rights and responsibilities without awarding damages or ordering parties to do or refrain from doing anything. Break. All right, let's talk about trial. Trial involves jury trial, court trial, consolidation actions and separate trials, judgment as a matter of law, judgment, motion to amend or make additional findings, motion to alter or amend judgment, and motion for a new trial. Jury trial. We've got jury trial right, jury demand, jury size, jury selection, jury instructions, jury verdicts, extra, and jury misconduct. Jury trial right. Law action tried on jury demand. Federal law will determine whether jury trial right exists unless state law claims in diversity actions. Jury demand. Must be served within 14 days after service of last pleading directed at issue to be jury tried. Party may specify issue for which jury trial is demanded. If not, demand is treated as jury trial request for all triable issues. Court has discretion to authorize advisory jury to issue non-binding finding on any fact issues and may either adopt or disregard advisory jury's findings. Party may withdraw jury trial demand with other parties' consent. Cases removed from state court. Party who made jury trial demand in accord with state law need not renew the demand. If state law does not require party to make jury trial demand, party need not make one after removal unless court orders. Jury size. At least 6 and no more than 12. One selected juror must participate in verdict unless dismissed for good cause. No provisions for alternate jurors. Jury selection. Preemptory challenges may not be made for racial or gender-based reasons. Court will allow 3 preemptory challenges for each party in civil cases, but unlimited challenges are permitted for cause, like bias or personal relationship to litigant. Jury instructions. Party may request court give specific instructions at close of evidence or earlier if court ordered. Prior to final arguments, court must inform parties of any instruction it proposes to give jury. Parties may object to court's proposed instructions on the record and out of jury's hearing. unless party objects on record to erroneous instruction given, proposed to be given by court. Unless party objects on the record to erroneous instruction given or proposed to be given by court, or to court's failure to give instruction requested by party generally cannot raise matter on appeal. Jury verdicts. Unless parties stipulate otherwise, verdict must be unanimous. Verdict must be returned by jury of at least 6. Form of verdict. Special. Written finding made by jury on each issue of ultimate fact. Judge determines those findings' legal consequences. General. Typically jury decision as to prevailing party, and, if plaintiff is prevailing party, damages amount. General with special interrogatories. Couples general verdict with special verdict, used to ensure jury independently considered case's material facts in arriving at its verdict. Extra. Court must poll jurors individually after a verdict is returned, but before jury is discharged. If poll reveals verdict is not unanimous, court can direct jury to deliberate further or order a new trial. Jury misconduct. Concealing acts related to his qualifications or giving false testimony during voir dire. Party must show jury failed to answer material question honestly and that proper response would have provided valid basis for challenge of cause. Other jury misconduct forms. Violating confidentiality of deliberations, being improperly influenced by non-jurors, or investigating facts outside of those presented at trial. Court may dismiss juror or order new trial. Juror may testify about whether extraneous prejudicial info was improperly brought to jury's attention, or whether any outside influence was improperly brought to bear on juror. Court trial. Court must make fact findings and law conclusions on record, at evidence close, or in court-filed decision, opinion, or memo. On appeal, court's fact findings can be set aside only if clearly erroneous. Consolidation actions and separate trials. Common law or fact question. Court may join any and all matters at issue, consolidate actions, or issue any other orders to avoid unnecessary cost or delay. Separate trials. Court may order separate trial of one or more issues or claims for convenience, to avoid prejudice, or to expedite and economize. Any federal jury trial right must be preserved. Judgment as a matter of law. We've got overview, J-Mole motion, renewed J-Mole, and extra. Overview. Challenges to evidence sufficiency in civil jury trial. Prior to jury submission, party may file motion for judgment as law matter, also known as J-Mole or directed verdict. After verdict and judgment entry, party may renew their judgment as a law matter motion, but there's a 28-day limit, also known as judgment notwithstanding the verdict or J&OV motion. J-Mole motion. Court must view evidence in light most favorable to opposing party and draw all reasonable inference from evidence in opposing party's favor. Extra. Court must also disregard any evidence favorable to movement that jury need not believe, and not consider witnesses' credibility or evidence's weight. Timing. Any time before a case is submitted to jury. Renewed J-Mole. If court does not grant directed verdict, movement can file an R-J-Mole no later than 28 days after judgment entry, or jury discharge if issue is not verdict decided. can be granted only on grounds raised in pre-verdict J-Mol motion. So, no original J-Mol, no R-J-Mol. Court may allow judgment on the verdict with the jury, order a new trial, or direct judgment entry as a law matter, the judge. Extra. J-Mol used to remove case from jury's consideration when there is legally insufficient evidence for reasonable jury to find in non-movant's favor. May file renewed J-Mol within 28 days after verdict or judgment entry to seek to overturn adverse verdict. If both motion for new trial and renewed J-Mol are submitted together, court will consider renewed J-Mol first, and if granted, conditionally rule on motion for new trial. Judgment. Court's decree or order that resolves parties' rights and relief demands in manner that permits decree or order to be appealed. Agreement with pleadings. Generally, judgment should grant party relief to which it is entitled, even if not requested in its pleading. Default judgment must not differ in kind or exceed amount demanded in pleadings. Cost. Prevailing party is allowed court cost without needing to file a motion, unless federal statute, rule, or court order provides otherwise. Attorney's fees. Claim for attorney's fees must be made by motion filed within 14 days after judgment entry, unless statute or court order provides otherwise. Extra. Under final judgment rule, federal appellate court generally has no jurisdiction to hear appeal until district court has issued final judgment, decision that fully resolves dispute on the merits. But interlocutory appeal statute allows certain orders to be appealed before final judgment entry. Motion to amend or make additional findings. Must be made within 28 days of judgment entry. May be combined with a new trial motion. Motion to alter or amend judgment must be made within 28 days of judgment entry. Motion for a new trial. Court may grant new trial with respect to some or all issues to prevent miscarriage of justice. Extra. If both motion for new trial and renewed J-Mol are submitted together, court will consider renewed J-Mol first, and if granted, conditionally rule on motion for new trial. Let's take a break. All right, post-trial. We've got alteration of or relief from judgment, appeals, full faith and credit, claim preclusion, and issue preclusion. Alteration of or relief from judgment, relief from judgment order. Court can relieve party of final judgment within reasonable time and no later than 1 year following judgment entry for mistake, inadvertence, surprise, or excusable neglect. Newly discovered evidence not previously discovered through reasonable diligence, or opposing parties' fraud, misrep, or misconduct. Other remedies. Court may also entertain independent action to relieve party from order, judgment, or proceeding. Grant relief to defendant who was not personally notified of action, or set aside judgment for fraud on court. Appeals. Notice of appeal. Generally, notice must be filed with district court clerk within 30 days after judgment order being appealed is entered. Final judgment rule. Federal appeals courts have jurisdiction over appeals of district courts' final judgments. If more than one claim is presented in case, or multiple parties exist, district court may direct final judgment entry as to one or more issues or parties, but only if court expressly determines no just reason for delay exists. Standards of review. Review of trial court's factual findings. clearly erroneous. Review of legal rulings, de novo. Review of discretionary rulings, abuse of discretion. Review of jury verdict, varies among jurisdictions. Full faith and credit. If court with jurisdiction over parties renders a valid judgment and parties received proper notice of action and reasonable opportunity to be heard, then judgment will receive same effect in other states as state where judgment was rendered. Claim preclusion. Valid final judgment on the merits. Court must have personal jurisdiction and subject matter jurisdiction. Defendant must have had proper notice and opportunity to be heard. Court must have nothing further to do but order judgment entry. And decision must be made on claim or defense's merits, not technical grounds. Sufficiently identical claims. Original and later filed claim must be sufficiently identical to be barred under claim preclusion, federal transactional approach. Sufficiently identical parties. Plaintiff and defendant must be same and in same roles in both original action and subsequently filed action. Summary. 1. Personal jurisdiction and subject matter jurisdiction. 2. Defendant had notice and opportunity to be heard. 3. Judgment entry only thing left. 4. Merits-based decision. 5. Claim same. 6. Plaintiff and defendant same. 7. Plaintiff and defendant roles same. Issue preclusion. Requirements. Same issue in law. Facts relevant to particular issue and applicable law must be identical. Actually litigated. Issue must have been actually litigated in prior action. Valid final judgment. Issue's first determination was made within court that decided its authority, and determination was made. Essential to judgment. Issue that constitutes necessary component of decision reached. Summary. We've got same issue, same facts, same law, actually litigated, court had authority, determination was made, and essentiality. Criminal prosecution. In prosecution's favor, you have preclusion. Issues determined in criminal prosecution in prosecution's favor are generally preclusive in civil action against defendant based on the same conduct. In defendant's favor, no preclusion. Issues determined in criminal prosecution in defendant's favor are not preclusive in civil action against defendant based on same conduct, because a plaintiff in a civil action was not a party to the criminal prosecution. All right, multiple parties and claims. We've got parties joinder, intervention, interpleader, claims as joinder, and class actions. Permissive joinder. Plaintiffs and defendants may join or be joined in one action if any relief right is asserted jointly, severally, or with respect to or arising out of same transaction, occurrence, or occurrence series, and law or fact question is common to all plaintiffs and defendants will arise. Needs subject matter jurisdiction. Defendants. Supplemental jurisdiction does not apply, so complete diversity must exist between plaintiffs and defendants, and each claim must exceed $75,000. Plaintiffs. Supplemental jurisdiction is permitted for jurisdictional amount less than or equal to $75,000, but complete diversity must still exist. In personam jurisdiction. Court needs in personam personal jurisdiction over defendant for proper joinder. Venue. Joinder is subject to applicable venue requirements. Summary. Plaintiffs and defendants both meet jointly, severally, or same transaction or occurrence, same law or fact question, meet requirements, and subject matter jurisdiction. Complete diversity. But with plaintiffs, supplemental jurisdiction is permitted, so it's less than or equal to $75,000 is permitted, whereas defendants, supplemental jurisdiction is not permitted, so each claim must exceed $75,000. And defendants also have to have in personam jurisdiction. All right, compulsory joinder, necessary parties, necessary for just adjudication. If necessary party is absent, then existing parties can't get complete relief, or disposition may impair a person's ability to protect his interest, or existing parties would be subject to substantial risk of multiple or inconsistent obligations. Subject matter jurisdiction. You need subject matter jurisdiction. So if jurisdiction's exclusive basis is diversity jurisdiction, then party can't be added if joinder would make venue improper, and court must dismiss that party. In personam jurisdiction. Court needs in personam personal jurisdiction over defendant for proper joinder. Venue. If joined party objects to venue and joinder would make venue improper, then court must dismiss that party. Indispensable parties. If parties cannot be joined because of jurisdiction or venue, then court may dismiss case and will consider the following factors. Extent to which judgment without party would prejudice them or existing parties. Extent to which protective measures could prevent prejudice. Whether judgment rendered in necessary party's absence would be adequate, and whether plaintiff would have adequate remedy if action were dismissed. All right, intervention. Intervention as of right, if not through federal statute. Non-party has property or transaction interest that is action subject matter. Action's disposition may impair non-party's interest. Non-party's interest is not adequately represented by existing parties. Permissive intervention. Court must consider undue delay or prejudice to original party's rights. Move-in has conditional right to intervene under federal statute, or move-in's claim or defense and original action share common law or fact question. Timeliness. Court will consider following factors. The time length movement knew or reasonably should have known its interest was threatened before moving to intervene. Prejudice to existing parties if intervention is permitted, and prejudice to movement if intervention is denied. Subject matter jurisdiction. Cannot be joined in case based exclusively on diversity jurisdiction if jurisdiction's exercise is inconsistent with diversity jurisdiction's requirements. Interpleader. Allows person holding property, stakeholder, to force all potential claimants into single lawsuit. Federal interpleader rule. The rule. Plaintiffs. Persons with claims that may expose plaintiff to multiple liability may be joined as defendants and required to interplead claims though claims lack common origin or are adverse and independent rather than identical, or plaintiff denies liability. Defendants exposed to similar liability may seek interpleader through cross-claim or counterclaim. Subject matter jurisdiction. Court must already have jurisdiction over all parties. Diversity jurisdiction. Only stakeholder needs to be diverse from claimants. Claimants need not be diverse among themselves. In personam jurisdiction. Court needs in personam personal jurisdiction over claimants to join them. Venue. Interpleader subject to venue requirements. Federal statutory interpleader, subject matter jurisdiction. Diversity jurisdiction is met if any two adverse claimants are citizens of different states, and property at issue must be $500 or more. In personam jurisdiction. Nationwide personal jurisdiction in service of process is permitted. Venue. Proper in any district where claimant resides. Claims joinder. We've got permissive joinder, counterclaims, cross-claims, and third-party claims, impleader. Permissive joinder. Party may join independent or alternative claims, whatever nature, against opposing party. Subject matter jurisdiction. Diversity jurisdiction. Plaintiff may aggregate all claims to satisfy a mountain controversy requirement. Federal question. Non-federal claims can be joined only if diversity jurisdiction exists or if claims are part of the same case or controversy as federal claim, so supplemental jurisdiction applies. Venue. Joinder is subject to venue requirements. Counterclaims. Must be answered within 21 days of service. Compulsory. At service time, counterclaim is compulsory if counterclaim arises out of same transaction or occurrence that's subject matter of opposing party's claim and doesn't require adding another party over whom court has no jurisdiction. Subject matter jurisdiction. Court will have supplemental jurisdiction, so don't need independent subject matter jurisdiction for original claim. Permissive. Party has discretion if counterclaim is not compulsory. Subject matter jurisdiction. You need both diversity jurisdiction and federal question. Third parties can assert counterclaims against original plaintiff or defendant and governed by counterclaim and joinder requirements. Cross-claims must be answered within 21 days of service. Claims against co-party may be asserted if claims arise out of same transaction or occurrence that is subject matter of original action or counterclaim, and new parties subject to joinder rules. Subject matter jurisdiction. Court will have supplemental jurisdiction, so you don't need independent subject matter jurisdiction from original claim. In personam jurisdiction and venue. Personal jurisdiction is satisfied because parties are already before the court. If proper venue over original claim, then party cannot object to venue over cross-claim. Third-party claims, impleader. Definition. Defending party, third-party plaintiff, can implead non-party, third-party defendant for liability on original claim. Timing. Can be asserted any time after complaint is filed, but third-party plaintiff must get court permission if filed more than 14 days after service of original answer. Subject matter jurisdiction. Court will have supplementary jurisdiction, so don't need independent subject matter jurisdiction from original claim. But if original claim is based only on diversity jurisdiction, then claims by plaintiff against third-party defendant must meet diversity jurisdiction or federal question jurisdiction requirements on its own. In personam jurisdiction. The court needs in personam personal jurisdiction over third parties. Class actions. Basic requirements. Numerosity. Case is so numerous all members' joinder is impracticable. Commonality. Law or fact questions common to class must exist. Typicality. Reps' claims or defenses must be typical of class. Adequacy. Reps must fairly and adequately protect class's interests. We've got numerosity, commonality, typicality, and adequacy. 3 situations when class can be certified. First one is prejudice risk. Separate actions would create risk. Class opponent would be subject to inconsistent adjudications, or if separate actions would impair class members' interest. Got numerosity, commonality, typicality, and adequacy. Final equitable relief. Class shares general claim, and injunctive or declaratory relief is sought. Single, indivisible remedy would provide relief to each class member, so money damages is not available. We've got numerosity, commonality, typicality, and adequacy. Common legal or factual questions must predominate over questions affecting individual members, and class action is superior method for bringing about controversies' fair and efficient adjudication. Class reps need not establish success's likelihood on common law question. We've got numerosity, commonality, typicality, and adequacy. Summary. Inconsistent adjudication risk, impaired interest risk, same general claim, injunctive or declaratory relief, single indivisible remedy, common law or fact questions, and superior method. We've got numerosity, commonality, typicality, and adequacy. Subject matter jurisdiction. Federal question, diversity jurisdiction, or 2005 Class Action Fairness Act. Diversity jurisdiction. Class reps must be diverse from class opponents, and at least one plaintiff must meet the $75,000 requirement. Numerosity, commonality, typicality, adequacy. Venue. When defendant class exists, venue requirements must be met, and class reps' residence, not class members' residence, is what matters. Numerosity, commonality, typicality, adequacy. Settlement or dismissal. Certified classes' claims, issues, or defenses may be voluntarily settled, compromised, or dismissed, only with court's approval. Court must direct notice to all class members bound by proposed settlement or dismissal. Numerosity, commonality, typicality, or adequacy. Judgment. Valid judgments generally binds all class members except class members who opted out. Numerosity, commonality, typicality, adequacy. Extra. Fed class actions proposed settlement must be approved by court to be valid. Proposed settlement may be approved only after court holds hearing and issues findings that settlement is fair, reasonable, and adequate. Numerosity, commonality, typicality, and adequacy. Extra. Class Action Fairness Act gives federal court alternate basis for subject matter jurisdiction over class action when class contains 100 members, at least one class member is diverse from at least one defendant, and aggregated claims as controversy amount exceeds $5 million. Numerosity, commonality, typicality, adequacy. And we're done. You made it through civil procedure. We'll see you on the next video.